May I start? Ma'am?
Yeah, please.
So, good evening to all of you. My name is Vikas Verma, former Assistant Advocate General and Co-Chairman All India Lawyers Forum. So, today is the AOR lecture series on the topic of leading cases for the preparation of the Advocate on Record exam. So, we have today's special guest, Justice Gyan Sudha Mishra, retired Judge Supreme Court of India, and keynote speaker Sri Siddharth Luthra, former Solicitor General of India and senior advocate. So we have with Sunil Fernandez, Advocate of Record, Supreme Court of India, and we have with Aditya Singh, Advocate on Record, Supreme Court of India, and Vinod Kumar Goel, Chairman, All India Lawyers Forum. So now I like request to Mr. Aditya Singh kindly give the welcome address in respect of our guest.
Good evening to all of you. So this is the second series of All India Lawyers Forum, which is organizing the AOR lecture series on the topic of leading cases. So I would like to first welcome our chief guest, Honorable Mrs. Gyan Mishra, former Judge, Supreme Court of India, and also Mr. Siddharth Luthra, Senior Advocate, former Additional Solicitor General of India, Supreme Court of India, and Mr. Sunil Fernandez, Advocate on Record, Supreme Court of India. And I would also like to thank Mr. Vinod Kumar Goel, the Chairman of All India Lawyers Forum, Mr. Vikas Verma, the Co-Chairman, Mr. Abhinav Singh, President of All India Lawyers Forum, for giving the opportunity to address the welcome note in the respect of our guest on this occasion. So first of all, I will just describe what is All India Lawyers Forum. All India Lawyers Forum is the foremost organization on national legal practitioners, bar associations, and law societies. It was established in 2009. It was born out of the conviction that an organization makeup of the bar association could contribute to national stability and peace through administration of justice. In the ensuing years since its creation, the organization has evolved from an association comprised exclusively of bar associations and law societies to one that incorporates individual national lawyers and entire law firms. The present members is comprised of more than 10,000 of individual national lawyers from most of the leading law firms and individual lawyers. During the lockdown, AILF has conducted a lot of seminars on different topics. So foremost, I will just welcome Gyan Sudha Mishra ji, former Judge, Supreme Court of India. Justice Gyan Sudha Mishra ji is former Supreme Court Judge. She was elevated as a Judge of Supreme Court of India on 30th April 2010. Justice Mishra has passed several landmark and notable judgments in Supreme Court of India, including judgments on conflict of interest in Srinivasan BCCI matter, landmark euthanasia judgment, that is Aruna Shaunbag matter, and the Delhi Upahar fire tragedy dissenting judgment, holding the management liable for the colossal loss of human lives and directing them to pay heavy compensation to be used for social causes like building trauma centers. Justice Mishra enrolled as an advocate in Bihar State Council in 1972, at the time when the legal profession for women in India was rather uncommon, and the profession was primarily considered to be main passion. Prior to her appointment as a judge, Justice Mishra was also actively associated with the activities of lawyers and the legal profession, and hence was elected as a treasurer, joint secretary, and member executive committee of the Supreme Court Bar Association, which is the premier association of the lawyers of the Apex Court of India. Also, I would like to thank Mr. Siddharth Luthra for joining us today. Mr. Siddharth Luthra, before I read this write-up, I just want to say that he is the ever-smiling Senior Advocate of India, an eminent jurist, and he was admitted to the bar in Delhi in 1991 and designated as a Senior Advocate in 2007. He was appointed as an Additional Solicitor General of India at Supreme Court of India from 6th of July 2012 for a term of 2 years, and he represented the union and state governments in a variety of matters, including those relating to fundamental rights, environmental laws, electoral reforms, criminal law, juvenile justice, education, and policy issues. Prior to this, he acted as the government counsel to assess the Judges Inquiry Committee in the regard to investigation into misbehavior alleged against Justice Sumitra Sen, Judge High Court of Calcutta, under Article 217 of the Constitution of India. Mr. Luthra has represented the Government of India in Delhi High Court from 2004 to 2007 as a senior panel counsel. He has represented as the special public prosecutor in the landmark judgment of Delhi gang rape case, Mukesh and another versus State of NCT of Delhi. And on 5th of May 2017, a three-judge bench of Honorable Supreme Court upheld the conviction and death penalty for the four appellants. He has obtained his degree from University of Delhi and an MPhil in criminology from Cambridge. He taught law at University of Delhi from 1997 to 1998. He is a fellow of the Cambridge Commonwealth Trust Society. He is also member of Delhi State Legal Service Society for 6 years. He is a resource person and teaches at Delhi Judicial Academy. He is a vice president of Indian Criminal Justice Society and sits on the advisory board of legal journals, which are very eminent, like Delhi Law Times and Delhi Reporter Judges. He is also visiting professor at Northumbria University at Newcastle, United Kingdom, and an honorary professor at MIT University, Noida, Uttar Pradesh. He has recently been conferred as Doctors of Law honoris causa by MIT University, Noida. He is also a member of Supreme Court Legal Services Committee and also a member of School Board of Hamdard Institute of Legal Studies and Research. He is empaneled as an arbitrator with Delhi International Arbitration Center. And most importantly, for the law students, he conducts and organizes International KK Luthra Memorial Moot Court in January of each year since 2005 on criminal law in memory of his late father, who himself was an eminent senior advocate in collaboration with Campus Law Center, University of Delhi. Mr. Luthra has published various articles and law journals, and is the I have a personal association with Mr. Luthra since 2007, the year I started my practice. Mr. Verma, please.
Thank you, Mr. Aditya Singh,
And
for
I will just
giving welcome. Thanks for giving welcome address. So now I'm going to request to Madam Justice Gyasuda Misra kindly inaugurate the today's webinar on the topic of leading cases, ma'am.
A very big hello to all of you. I feel immensely pleased to associate myself with today's event, and it fills me with pleasure, but also with a lot of nostalgia. I recollect my own days when I was strolling around in the Supreme Court corridors and preparing for the AOR exam, and was barging into the judge's library off and on. There has been, insofar as the subject of today's topic is concerned, I would rely upon my very dear, I would say, colleague, not merely a member of the bar, but we had been colleagues in the bar and thereafter had good opportunities to interact with each other as a counsel and as a judge. I would rely upon the contents of the leading cases on the able advocate, senior advocate, Mr. Siddharth Luthra. What I would like to share with you, first of all, is that there have been a lot of, dual thoughts on the relevance of the AOR examination and the aspirants of the AOR. I think at times they get quite confused whether to continue as a lawyer without taking up the AOR exam, because as a beginner I kept hearing that you it's not really relevant to clear the AOR exam, and you can afford to be a lawyer, an arguing lawyer, and you can obtain the signatures of an AOR just to file it. But experience taught me that self-help is the best help, and that to survive as a beginner, I don't know whether this can be taken as an accepted view or not, but I personally felt that it's a very good platform for the beginners to start in the profession and survive, and it gives you the choice of both the fields. Whether if you want to be an arguing counsel, you might do the filing work as also appear in courts. And in my experience, I noticed that if an advocate is also an AOR, the client, you give a chance to the clients to opt for an AOR as also an arguing counsel. So, first of all, I would like to address the able aspirants of the AOR exam that they should, I would suggest that they should focus both as a filing and a pleading counsel, and not merely as a pleading counsel, but also as an arguing counsel. So, having started with that, I would just stop at this moment. Mr. Vikas, please let me know, and I have to stop, because even as a judge, we have not lost the touch of talking.
No issue.
So give me a bell when I need to stop. And given a chance in this lockdown, the tendency to speak more might be there. So, having said that, the aspirants of the AOR exam, of course, if they have decided on it, it's a very good choice. And so far as the preparation of the AOR exam is concerned, I guess all exams have to be taken very, very seriously. Because why I say this, because you see, whatever I would share from my experience. I was told that AOR exam, it's very tough, and in those days, having passed out from college, having done the post graduation, and I felt, we were doing at least 8 or 12 papers in each year of the LLB, and also in the honors papers, appearing just in 4 papers would not be tough, and I took a bit lightly. But then I felt that, because in those days we were having the accounts paper also. So fortunately, the accounts paper have been weeded out, I'm told, and it's a good substitute that leading cases have been introduced in its place. Because in my time, Supreme Court practice and procedure paper had 2 parts. One was the Supreme Court practice procedure, and other was the leading cases. So it's good that because leading cases is a very important part of the OR exam, which is relevant not merely for the examination, but also in future years of practice. Now, switching over straight away to the subject of the leading cases, I don't know how many of you have done the law clerkship with the judges, because I felt that law clerkship judges teaches them a lot, in the sense how to distinguish between relevant and irrelevant. And of course, it happens with practice. But leading cases, when you prepare for the exam, from my experience, and even as a lawyer and as a judge, the judgments are very, very, most of the leading cases especially are very lengthy judgments. Though, so the AOR aspirant, I would suggest that they must try to, first of all, one should understand the facts briefly. Secondly, what is the point of view which have been stated in the judgment, the arguments advanced by the petitioner side, and thereafter by the respondent sides, and then the judge's point of view comes. It is accepted, why it is accepted, and if not accepted, why it is accepted, and the last part of it is the ratio of the judgment. Of course, ultimately the ratio of the judgment finally survives. Like, that's the crux of the whole judgment. So while preparing for the AOR, by the AOR aspirants, leading cases, you have to uh, focus all the three aspects in a condensed way. Like, there's a tendency, especially during exams, to express more whatever a candidate has read and learned. But then that will, you have to uh, uh, what I feel is that you can remember the synopsis of of the entire judgment, and uh, and try to weed out whatever is not relevant and relevant. But at the same time, as a judge, I noticed that many a times uh, that deciphering was too concise, and one wouldn't understand what exactly is the relevant if you just read the ratio, that this is the ratio, and the lawyers generally say that we can skip over this, skip over that. But one, like your examiner, I guess, would be in a position to understand if you have understood the entire crux of the judgment or not. And side by side, it's not the correctness of the this part, I guess, is very important to, while preparing the leading cases. The students, I would suggest that they need not be too concerned whether their answer is right or wrong, because answer is right or wrong, but your reasoning skill should reflect what exactly should come out of that. So these are the random thoughts. Of course, I've lost touch with the exam, and I think I'm getting a bell. So, uh, oh, fortunately, it's not yours, Vikas. I thought it was your bell on the. So that's the leading cases. I would say that basically the student should not be really be obsessed with the right or wrong answers. And I don't know the perspective of the examiner, because I've never been a teacher or an examining the answer sheets of the students. But what I understood was that it's not the it's not the it's not the correctness of the answer which matters. It's your analytical ability and to apply in the facts circumstances. So I would now wind up by wishing a great future, wishing all success to all the aspirants, and next time invite me when you pass out for a gala dinner. Thanks to the initiative, to the for inviting me to this, the, I would say, maiden appearance for the AOR examination. Wish you all the best, and in the end, I appreciate the initiative also of the AILF, that in this period you are making the constructive use of the time and giving us also an opportunity to share our thoughts and experience. Thanks, thank the Lord. Wish you all the best. Keep early.
Thank you, Lordship, for inaugurating this webinar series, which is very important for the lawyers across India. And thanks a lot for your valuable knowledge and your wisdom. So now, may I request to Siddharth Luthra sir, so kindly give your address on the topic, which is very important.
I must first uh, wish you all a very hearty thanks for giving me this opportunity. And it's a pleasure being in the presence of Justice Gyan Sudha Mishra, who has very kindly opened the webinar. I've had the privilege of being associated as a lawyer with and appearing before Justice Mishra, and I can tell you, uh, it was always intellectually a pleasure and challenging. And I have always cherished the moments. Justice Gyan Mishra, from the day she entered the Supreme Court, was very clear. She was independent, she had her own views, and she was never a pushover, as sometimes judges who come in as junior judges to a bench are, and assertive. And I have seen that assertiveness, and yet with the assertiveness, there was a grace. There was firmness, but there was always grace, and it was a pleasure. There was always a hearty banter and always an attempt to try and find a legal or equitable solution, as the case may be. And I have really enjoyed the time spent in a court and thereafter even on public functions. Today, of course, we are again together at a public event, but unfortunately, space divides us, technology joins us, and that's where we are. Justice Mishra has really, I'm going to talk about some of the cases, but that's the second part. And I'm going to run through some of the important cases and some titles, some issues. Justice Mishra has really told you what I wanted to say. And that was to point out that the AOR exam is not just about learning the facts or the name of the case, but it is about your analytical skills. I can share with you, last year I was one of the persons who set the examination paper, and I will not be doing it the next year, so it's okay. So I can speak comfortably. So there were two things that troubled me particularly. Issue number one, which would have troubled you, and I hope it will not trouble the future aspirants, because there is an attempt to upgrade and update the cases that will be in the list, because some of the cases have either been overruled or reconsidered or diluted. And plus, there are areas of law such as competition law, such as medical negligence law. There are great areas of law, competition law, that have come in, technology law. There's a great development in intellectual property. So all these areas have come in, and frankly, we need to be a little more forward-looking, because practitioners today find that it is not just the traditional taxation, criminal, civil law. There are so many more fields, and that's what your knowledge is to be tested on. And then again, the issues of analysis. So this year we had made what I would call compound questions. For example, there was a question on Antule, AR Antule's impact on Hura, and what was the interrelationship between them, and the curative procedure. Now, this had three parts. One was Antule, the background to Antule, the concept of Antule. The second was Rupa Ashok Hura, then the rules, the guidelines that Rupa Ashok Hura made, and then the Supreme Court rules. And we also wanted to know, how is this law developed? So there were instances of whether the Hura principle is absolute, whether the curative rules have, and how judgments have further gone and examined this issue. So these are three or four parts to the same question. Unfortunately, we found a lot of examinees. As an examiner, I can tell you, I had fair share of the examination books. I don't know about my other colleague, but I found a lot of people would say, all right, there's Antule and there's Hura. Now, what's the relationship between them? Well, Hura followed Antule. Now, that's, with respect, not good enough. That is not what the question wanted or merited. And therefore, there's a lot of it. So today, I'm just going to broadly tell you some of the areas which you need to focus on. One of the primary things, as Justice Mishra rightly said, was don't just look at the periphery. don't just look at the broad areas of the judgment. There has to be an in-depth study. Don't even rely on the head notes, because head notes can be deceiving. When we were doing the case of presidential pardon, death penalties, reported judgment, Shatrughan Chauhan, then V. Sriharan, we were dealing with a judgment called the Sony Ben. It's an 89 Supreme Court decision. And there was a lot of concern whether the sitting judge should have used whether that was a dissenting view or a supplementing view. One journal recorded it as dissenting. We finally had to pull out the Supreme Court reports to see which was the authentic version. So that sometimes leads to aberration, because if there is an error made by the editor, that's going to be carried forth in the head note, and that becomes a problem. So you need to have that level of analysis, that level of deep study. I would broadly say that the areas that will need to be covered definitely will be, let's start, and I'm not doing this chronologically. One of the important areas is always reservation, where the TMA Pi decision, Islamic Academy, the fact that aided, unaided institutions established by minorities, non-minorities, their right to establish, administer educational institutions of their choice, and the regulation aspect there, and the constitutional issues arose, the manner in which Unni Krishnan was dealt with, and what are the questions they framed, what are the questions they dealt with, what did they leave open. There were different judgments, different views, and what is the sum total of that decision. So this becomes very important, because it's not just about minority institutions. So you need to really have a deep study. And then not only this, you can't just leave it at this. You have to study linguistic minorities, religious minorities, the St. Stephen's College, because that has an interrelation that's dealt with. That's question 9. And then you have Justice Khare's view, Justice Kirpal's view, Justice Kadri partly dissents, Justice Pal dissents, Ruma Pal dissents, and Justice Varyava and Bhan partly dissent with Justice Kadri, etc., 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 and I'm going to get into more details. Then you have Inamdar's case, 2004 8 SCC. TMFI comes up for consideration. There's an interpretation of Islamic Academy, and then PA Inamdar. So, you have all these 3 cases which must be, there is a web that joins them, and we must understand what that whole story is all about. There are also going to be issues as to the strength of the bench and whether this interpretation could have been done, but that depends. It depends on the examiner, whether the examiner will or will not raise it. The other area, and I'm going to go area by area, which I think is very important, which is always stand firm, is resolutions. So whether it is Indira Sani's case, which again touches upon creamy layer, etc., 50% rule, the 77th Amendment, or Ashok Kumar Thakur. Now, in the socially and educationally backward classes and the identification of the backward classes, the exclusion of the creamy layer, both these are very, very important decisions, and the interplay of these decisions in the context of the amount of reservation that is constitutionally permissible or permissible by the Supreme Court becomes a very, very important consideration for any examinee who is taking the AOR exam. You see, as an AOR, you are the interface, and as Justice Mishra rightly pointed out, in the Supreme Court, it is important to be either an AOR or a successful junior of a successful AOR. There are lots of those. Sunil is here, there are others here who are very successful, and they have a lot of work. So the juniors get a lot of opportunity. Alternatively, you have to be a senior counsel. It is the counsels in the middle who are not yet designated, trying to make their name. They often do not get the necessary traction in the court because of various reasons, but that's the fact. And I remember when I started coming to Supreme Court, before I became a designated senior, Aditya Singh Senior was there at the time. He and I used to work a lot together. He's now Justice C.D. Singh in Allahabad. And one day he told me, this must be the year 2004 or 5. He said, भाई साहब अगर आपको सुप्रीम कोर्ट आना है ना प्रैक्टिस करने के लिए, तो आपको सीनियर गाउन जब तक नहीं मिलेगा तब तक मुश्किल रहेगी, बिकॉज आपको ब्रीफ नहीं किया जा सकता. एंड आई हैड अ फेयरली डिसेंट प्रैक्टिस इन द हाई कोर्ट, बट दिस इज अ norm. So the advantage of being taking the AOR exam, clearing it, is that you suddenly get catapulted into a recognized and an exclusive club, and that club entitles you to have access. You are the interface between lawyers and the court. And while there are, of course, as Justice Mishra rightly pointed out, a category of lawyers who are filing lawyers, as I would call them, I think the AORs provide a certain quality to the Supreme Court practice, and without the AOR institution, it would fall by many notches. So whether it was Privy Council agents or Federal Council agents or attorneys, Federal Court agents or attorneys, without the AORs, the quality of filing, the quality of advocacy is seen. I see, and I have seen over the years, that lawyers who practice in this court, their training is to make them very crisp. Having come from the trial court myself and then gone to the High Court here, I had to relearn a lot of things, and this court and my AOR friends taught me a lot, and I'm very grateful to them. Okay, so I've talked to you about Inamdar also, and Indra Sani and Ashok Kumar Thakur. Another field which we always like to touch upon is the right to education. So the Society for Unaided Private Schools of Rajasthan versus Union 2012 judgment is very important. It's on the legislation. It interprets Article 21A. Now, how do you get good results in that exam? You can trace the history of 21A. You can talk about how it first was referred to and how it came about. Then cut straight to the legislation. Then to this, and don't forget, after this, if I recall correctly, there was a constitution bench in Pramati's case, in Pramati Education Society. Now, that's a very important development. And these are brownie points in how to enhance the quality of your answer, because you then show your in-depth understanding. It's not about just 5 principles that they say, and we don't, as an examiner, you don't want people to mug up. I mean, I'll come further and I'll tell you another classic example, because one of the cases on which I had spoken is just below. So this makes it qualitatively superior. And here again, the question that was asked was about majority and minority view. There are so many people, so many examiners who just gloss over the minority view. I mean, I was surprised to the point of being disturbed that why is nobody touching the minority view? But these things happen, and it's important. There is another area which is very important, and that's criminal law. So the rights of an accused, I'm going to deal with rights of victim later, become very important. And in that, T.K. Basu's judgment is very important. This time the exam said, did D.K. Basu impact the CRPC? How does its interface with the CRPC? So there are two paths. The answer really wanted us to say broadly, and I'm telling you this broadly, I'm not getting into details, is D.K. Basu is a case which deals with a human rights issue, rights to people in custody, right to access of a lawyer, appearance before court, right against torture. D.K. Basu also creates a remedy. Contempt is the remedy. There are service law implications for the person who breaches the guidelines in D.K. Basu. But these are very important things, and these are the developments in the law. Most examinees will just quote or repeat some of the directions in D.K. Basu, but that's not enough. We need, as an examiner, you would need more than that. And the issue of right to life vis-a-vis the right to limit that liberty and the reasonable restrictions and the legitimacy, and how some of the directions of D.K. Basu overlap with what was in the CRPC or other laws. Yet at the same time, some of the directions in D.K. Basu dilute Nandini Satpathy, which was very broad, and later how they get incorporated in the CRPC. As you will see, Section 60A of the CRPC. So that's another aspect. D.K. Basu, of course, gets followed in Z versus State of Bihar 2018 decision, and in Jini Johor, where compensation is granted. So these become important issues to be considered. The Constitution. We deal always with the basic structure principle. Now, the fact is, the basic structure, I don't think any examiner is going to ever ask you to do at least in my lifetime, I would never ask anybody to write about Keshavananda Bharati, because if you were to do that, you would not need 3 hours. You need 300 hours perhaps to write about that one case. So Keshavananda Bharati is something which is mentioned very often, but you have judgments like Minerva Mills, 1980, Volume 3, SCC 625, which deals with the 42nd Amendment and the validity of certain sections, Section 4, Section 5, which makes certain changes, and some of them were held to be unconstitutional and void. So it's a very important, very, very important case, because the 368 amendments, Article 368 amendments, were held unconstitutional because they removed limitations on the amending power of Parliament, and that was said that impacts the basic structure, and therefore that was not accepted. In this line, you will also have judgments on presidential rule. So Article 356. S.R. Bomai's case 94-3 SCC is very important. There's Rajendra Prasad later on, the governors also, removal of governors. These are very important cases. Bomai's case is a 9-judge bench. It's about a presidential proclamation under Article 356. The proclamation is removing Madhya Pradesh, Himachal Pradesh, Rajasthan, Nagaland, etc. And all of these get challenged. Matter comes up to the Supreme Court. It was clearly held, that power under Article 356 is not absolute, not arbitrary. The president cannot impose it on mere whim and fancy, but there has to be reasonable cause. S.R. Bomai gets followed in K. Puttaswamy, and that is where the law is today. There are also important areas of consideration, for example, the fundamental rights chapter, and where you can exercise your fundamental rights. So Article 12 is a favorite amongst examiners. Pradeep Kumar Biswas, there are a number of decisions. The expansion of this doctrine of Article 12 is also very important, because you will see that today bodies such as the Board of Cricket Control is amenable to writ jurisdiction, and there is an increasing impact to see what's the functionality of a body. So the test is public duty. It's not just about the nature of the structure or whether it's a society or otherwise. In Pradeep Kumar Biswas' 7 judges bench laid down a very clear and interesting decision that whether the body is financially, functionally, and administratively dominated by or under the control of the government. So if it's a merely regulatory control, for example, if there is the regulator sitting on a body, so that does not make it state. The regulator may be state, but the fact that you're under regulation doesn't make you state, because everybody is subject to law. Now that law may be by government, by regulators, but that's a separate issue. Now, I also want you to see the right to property under Article 31B and 9th Schedule. Coelho's case is a very important case, because Coelho's case 2007 2 SCC determines the character of protection by Article 31B added to the 9th Schedule by the 1973 Amendment, being the date on which Keshavananda Bharati is pronounced. This is a very important case and often referred to. And the question is whether the 9th Schedule legislations can or cannot be invalidated and exercise the judicial review. And the point is, if it's violative of the basic structure or abrogates or abridges rights under Part 3, then such amendments will have to be tested under Article 21, read with 14 and 19, and Article 21, 14, 19, as you know. Maneka Gandhi's case is the important case. So you had Gopalan, then you had Maneka Gandhi. These are very important decisions which will merit consideration. On the scope of Article 226, I always commend people that you must read it. You must look at L. Chandra Kumar, 97.3 SCC, but that becomes an area of consideration. Now, let me tell you very frankly, when we are having this conversation today, I'm taking you through some of the cases which are important, which have been important in the past, and which will perhaps be in the coming year's examination. Whether they will or not is a matter for the committee of judges to decide. So please don't take it that this is a pointer as to what the examination paper is going to be out of. But These are areas which normally find way in the list of important cases. There are so many important cases. If you see, in the last about 5 to 7 years, how many constitutional benches have sat? How many judgments have come? 5 judges, 7 judges, 9 judges. Now, this is changed a lot of the views. For example, privacy. Privacy was not a right. Now it is a recognized right. You should assume that you will have to read the Puttaswamy judgment threadbare, and then the 5 judges, because on Aadhaar, then on money bills, because these are all parameters to be considered. So L. Chandra Kumar, as I said, is an important judgment on the scope of 226. One of my favorite issues, which I mentioned earlier, was Antole versus Andrupa Ashok Hora, the development of law, and the curative decision, and the legitimacy of this jurisdiction. Is it legitimate? Is it acceptable? Or should a court of record not have the power to correct its own jurisdiction? And if you look back, there's a beautiful decision, Roger de Comptoir, 1885, I think, quoted in Antole and also further. And that became the basis of this evolvement of curative jurisdiction, because it was important for the court to be able to correct errors which are so gross, whether in terms of natural justice or otherwise. It's not that the Supreme Court wasn't doing it earlier, but they wanted to formulate a mechanism. So there should be a formalization. And for a court, for a country which operates on the rule of law, it is important that there is consistency both in merit and in process and procedures. So that is, as I said, the judgment in Antule's and Rupa Ashok Hora's case. And it is important to see what is the nature of relationship between these two cases, and whether Article 32 will lie, will not lie, and the concept ex debito justitiae. We use this phrase very commonly, but we must understand the import of this expression very carefully. Now, another area which I would commend is industrial law. Why is this important? This assumes greater importance today because there is a desire and an attempt to dilute labor laws. Some may say it's a dilution of labor laws. Some may say it's not a dilution of labor laws, but it's actually a recalibration of industrial law and labor law in order to boost the economy. But the fact is, judgments such as Bangalore water supply, which dealt with what is an industry, will clearly have to be revisited, won't they? So this becomes very important, and judgments on trade unions, they're going to be looked at, and these are crucial. There is a constant debate about the power of the Supreme Court to lay down guidelines, or the power of the court to legislate. In Vishakha's case in 97, 96, they said it can be done. They did lay down guidelines. Those guidelines today are the law, guidelines on sexual harassment at the workplace, and they have culminated into the 2013 legislation. Yet, you will find that in P. Ramachandra Rao, 2002, 7 judges said this should not be done. Recently, in Dr. Ashwini Kumar's case, they said it should not be done. In Ritesh Sinha's case, the judge bench said it ought to be done. So there is this entire debate which is lingering, and I believe it is going to be revisited. And it's a very important and interesting area to be considered and to be read, because this entire debate. So please take it. The questions should order. One way of asking a question to a student is, what did this judgment say? But that's not what you're going to be tested on. Very often the examiner, and remember, we are lawyers, all your examiners are lawyers, we're happy to see you be tested. I must also share with you the average time, at least I as an examiner take on the first, let's say I had about, let's say I have 300 plus papers. On the first 20 odd question papers, the average time on the exam to check that paper is about 2 hours per paper. It is only later that one goes down to about 30 minutes per because you start speed reading and you get a sense of what is becoming. And one has to revisit as an examiner the first 50 papers to see whether you've been too conservative, whether you've been liberal. But that exercise is to be done. So it's for an examiner, it's important that your answer is lucid, clear, it's conceptually uh, demonstrates your knowledge. As an examiner, I do not necessarily want an answer which runs into 20 pages or 10 pages, depending on your time. The amount of pages is not important. What is important is the content, the simplicity of language, not necessarily a repetition of the phraseology of the decision, unless where certain phrases are called for. But the the understanding of the candidate and the analytical ability and presentation, of course. A neat handwriting does help. I do hope that in the year to come, we will be able to have laptops introduced for you to be able to type, because I know a lot of people of the younger generation are not comfortable writing in longhand. And I believe that that should also be introduced, hopefully, this year, if not the next year, but that's also something under contemplation. There are judgments galore. I can talk to you about anti-defection law. There are judgments on Kyoto Holohan's case. It's an important area. There's freedom of speech. That's a new 2010 decision on Shivaji. Professor Lane's book. It's a very important decision. Then the book on Mahatma Gandhi as a public personality and whether you can be critical, not critical of him. Now, these are the judgment of Subramanian Swami, two judges bench on defamation. Please take it. It is not that every judgment that is to be asked has to be a 5 judges bench or a 7 judges bench. It may be a 2 judges bench. For example, the judgment on 65B of the Information Technology Act, 65 and 60, the judgment on the Information Technology Act, Shreya Singhal, is a very important, 66A is a very important decision. It's a very crucial decision because it lays down concepts of freedom of speech. Or, for example, Nikesh Tarachand Shah, which lays down the principle regarding the twin conditions, which is the subject matter of debate again in the Supreme Court in the context of Section 212 of the Companies Act. So these become very important. Or, for example, like last time we asked about the 2G decision, and we asked about the decision in the presidential reference and their interplay. Most people tried to link the two together, not realizing that one of the important things, opening things in the presidential reference was they said, we will not relook at the 2G decision. The government has dropped that question which they had framed. So while 2G was important, 2G laid down a principle of auction, but the presidential references, other than 2G, auction is not an absolute principle. Amongst the interesting decisions which I find is the decision of common cause, which is on the right to die. I think it's a very, very important case. It's a case which merits great consideration. I'm also partial to it because I must say I'd appeared in that at the initial stage, but that's not why I'm commending it. Since I'm not an examiner this year, so you don't need to worry, but it's an important decision because it, from Aruna Shanbag, which was mentioned, till now, that's an important decision. I believe Justice Shamsudha Mishra had been part of the Aruna Shanbag bench. So it's an important decision which interprets and deals with Aruna Shanbag as well. And it's a crucial case which needs consideration. Lots of common cause cases, but this one I would definitely commend. There are procedural laws, there are substantive laws, there are going to be there is normally always a idea to put in something on taxation. There are questions which will be asked on interpretation of fundamental rights, as I said, the right to die. And amongst the important new decisions will be Navtej Singh Johar, the decriminalization of Section 377 and J6. Now, there's an interesting issue there. The Delhi High Court diluted 377, read it down. Supreme Court dismissed, two judges dismissed. The curators were pending. Navtej Singh Johar gets filed. The matter comes up, referred to a constitution bench. Constitution bench decides this issue. And having decided it, Suresh Kumar Kaushal came much, it's just left pending and it becomes a dead letter. But this is a very important decision because it is a complete interpretation of a person's individual, a person's privacy and private rights. And the decisional autonomy concept is a very important issue that is considered here in these matters. Of course, 377 will continue to apply to non-consensual sexual activity against adults or against minors, bestiality. It is only consent that is now clarified. Commercial law is very important for us. So arbitration laws, Arbitration and Conciliation Act, Patel Engineering 2005, the old judgment of Renu Sagar, the decision in BGS Soma, it's a 2019 decision on seat of an arbitration, the Balco decision, which is relooked at, Roger Sheshwa's case, all of these become very important for consideration, including the English concept in Sheshwa's case. An important area will be the right to information. CBSE versus Aditya Bandyopadhyay, the High Court decision, what happened in the Supreme Court, why it happened, and what is the extent it gives you the right. So today, as examiners for the AOR exam, you can actually get your answer book under RTI. You can't get a recalculation done without that, but you can get a retotaling done. And that makes the job of an examiner very tough because the examiner then has to work very hard to make sure that they don't make any silly mistakes or they are very accurate in their marking of papers. And you have to countersign, you have to initial, you have to make sure that everything is kosher. Of course, the registry does a yeoman's job. Even after you've given in your results, they check, they come back to you, you then correct it, and there's a long exercise. So, as I said, the nature of relationship, fiduciary relationship, all of these are going to be tested. I understand it is almost 6 o'clock, so I will not want to belabor too long. But as I said, there was DK Basu on accused rights. There's State of West Bengal, 2010, 3 SCC 571 on the victims' rights, the right to a free and fair investigation under Article 21, Constitution Bench decision. Very, very important. And then, of course, Nandini Sundar, which is 2011, on the right of Naxalites and people who were resisting the force of the state, and that whole issue regarding that force, the vigilante force that the then state of Chhattisgarh had set up, and the role of security forces. In criminal law, Selvi is an important case. It's on the right of the nature of investigations that are permissible, electronic tests, narco analysis, polygraph, brain mapping, and whether they are constitutionally permissible or not, and to what extent, and whether, if you accept, is that a breach of a right under Article 20. Zahira Sheikh is important. You get asked on this sometimes because the scope of an fairness of trial, the role of a judge, role of a prosecutor, provisions under 311, 391 CRPC, all of these, the right to fair trial is given new teeth by this judgment. I have a personal remembrance of this case. I was appearing as a lawyer and my matter was coming up next. And the honorable judge, and I was afraid that my matter was one of those dicey matters. I had an acquittal in my favor. And by the time Zahira Sheikh was over, there were so many contingencies. The bench said, listen, I don't think there's much, Mr. Luthra, in your matter. And I was very happy to say I kept quiet. And the AOR struggled to make his case, but I got a dismissal in my favor. I was for the respondent. We did in the High Court. I came from a Samsari court. Subramanian Swamy, CBI 2014 Constitution Bench, is an important case. It deals with Section 6A of the Delhi Special Police Establishment Act, which was struck down. because it provided a restriction or a bar on investigations or inquiries against officers of the rank of joint secretary and above. This is still being tested in CBI versus Ashutosh Kishore, whether it's retrospective or prospective, but that consideration is happening. What is important is that this is provision has now been brought in by virtue of Section 17A of the Prevention of Corruption Act, and therefore this judgment holds a very important principle, because in terms of the Sarbanand Sonowal's case, can you really overcome a legislative bar like this? So this becomes a sensitive and an important case, a case which will merit consideration and is likely to come up in the event that 17A challenge is decided. And even if it is not, it's likely to come over the 6A. Retrospectivity, prospective application is also considered. 17A is also under challenge, I believe, by CPIL. Then you will have Joseph Shine versus Union of India 2009. This is on bigamy, and it's an important case on the, whether 497 of the IPC was a excessively penal provision, whether the concept of constitutional morality, the relevance of law of adultery on marriage, on liberty, dignity, equality, autonomy of an individual, and whether the state should have a interventional approach or a minimalistic approach in the criminalization of offenses. So that will also become an important case for you to consider. We have the Constitution Bench decision in Sushila Agarwal, which is, by the way, again under reconsideration as to whether it's good law or not. It's a 2020 decision, January 20, and its interplay with CBIA. Does it reiterate CBIA? What does it do with CBIA? There is a legislative change in 2015-18. Have they been adequately considered in Sushila Agarwal? Do they inform Sushila Agarwal? Or is Sushila Agarwal decided in the pre-2005 legislative amendment scenario? That means will it again need reference to a larger bench? And how it strike down, it says Salahuddin is bad, Metro is bad, KL Verma is bad. And then seeks to take principles of all three and then repeat them. So this is the analysis which you would be expected to do. Of course, separation of powers, Article 194, Amrinder Singh versus the Punjab Vidhan Sabha is an important decision, and that is something which is crucial to any debate or any consideration. Amongst the areas to be explored will be environmental law, Goa Foundation, TN Thirumalan case. All those cases, they will have to be considered. The common cause case about mining in the state of Odisha will have to be considered. And this is a new area which is going to have greater emphasis. In taxation on the last occasion, as you know, we had sought to an understanding of the Vodafone case, but that was not only taxation. That was also about corporate law and corporate structures, because that judgment lays down two sets of principles: corporate structures and tax evasion versus tax planning. So there are two very interesting concepts there amongst from other major concepts, but then we're not going to ask you every concept. Right to health, medical education are becoming increasingly important cases, medical negligence. So whether it be Balram Prasad versus Kunal Saha's case, or Malay Kumar Ganguly's case, or it is later cases following that line, whether civil or criminal, or the Jacob Matthew case, all of these are very important cases in determining what is the nature of liability and what is the nature of test, and how have we changed from we are following the Bolam's case. Should it be followed? Should it not? Is the UK principle good or bad? Environmental law, of course, as I said even earlier, is going to be important. And then there are going to be issues such as sanction, issues of Hindu laws, religious laws, whether it be Islamic laws or Hindu laws. There'll be administrative law issues. T.S. Nakara's case is a case in point. The list will become endless. But as I said, you will have to slot it as there are going to be sections on procedural law and constitution. There are going to be sections on substantive law, civil, criminal, taxation, intellectual property, as the case may be. There are going to be sections on substantive law. And what we look for as examiners is when there is a reference to a judgment, whether you have as a candidate been able to pick up the nuances of the development of the law that has taken place by a certain decision. The Ayodhya case may be a fair question that may be asked, and the nuances, the interpretation that's happened, whether in Aadhaar, Puttaswamy, as I said earlier, or the scope of analysis. I would say examinees must not hesitate in answering questions in terms of their analytical ability. As long as your analysis is not grossly wrong, as long as it's a reasonable analysis, it's a logical analysis, you're not going to lose marks. But if you say something totally bizarre, contrary to the decision, then we're going to have a. And therefore, that's the kind of exercise that needs to be done. So, also areas such as religious freedom, live streaming, and the challenges that are going to happen because of the new COVID environment. Insolvency law is a very important area. Swiss Ribbons is an important case, definitely worth visiting. There are a number of decisions now on IBC law, so please take it, whether it be the IBC law, whether it be the interpretation of IBC and the other insolvency laws or the Companies Act or criminal law, all of these will be considered. In religious cases, Shaira Banu is a forerunner. In competition law, I'm partial to the decision of Competition Commission versus Bharti Airtel, which is Justice Sikri and Justice Bhushan, and very interesting decision, partly on administrative law, partly on writ jurisdiction, partly on competition law. A very important case which needs consideration. There are other decisions, for example, Rajasthan Cylinders on competition law, then Competition Commission versus Coordination of Committee of Artists, again 2017 on the Mahabharat serial. So there are a number of such cases, Excel Crop Care. There are a number of cases which are now coming in this area of law. So please take it from me. These are areas which you must start preparing now. And last but not the least, don't forget the Indore Development Authority. You're not being able to, I don't think it's going to be complete without land acquisition law in this year. So I'm going to end here now. I've taken a substantial amount of time of all of you, and I'll leave the floor open for questions if any. Thank you.
Thank you, sir, for your knowledge and your lecture. Sir, can I ask you one question? The Durgesh Gupta from the Mumbai. Yes, I am audible.
You're very audible. I can hear you very well, but I can't
Yes,
see
sir.
you.
Okay, sir. Okay. Yeah. Okay, sir. Sir, one question from the Mumbai. Mr. Durgesh Gupta asked, the judgment run into the 500 and 1000 pages and sometimes in paper. It is asked about the minority judge views. How can one simplify and remember those views, sir?
I think if judges like Justice Gyansudha Mishra can work hard enough to write these long judgments, then as lawyers, we need to be ready with them. There is no shortcut. You never know when a minority will become a majority. Look at the law. Look at Puttaswamy. It's a case in point. It eventually, privacy was recognized as a right. Initially, it was not. So minority views are very important because they are like the conscience, voice of conscience to be heard perhaps in a day in the future. And therefore, we often ask you on the minority. Sometimes it is the supplementing you. It may not always be a dissent. Needless to say, the judgment will have to be read as a whole. There is a case pending in the Supreme Court, and I can be corrected by my friends here, as to whether if you have a five-judge judgment, is that going to be 3+2? And if it's 3+2, how should that three judgment be treated as against a five-judge unanimous judgment? So these interpretations are in the anvil and they'll be important. But to put it simply, there's no shortcut.
Thank you, sir. The one question from Ma'am Justice Gyasudha Mishra, ma'am. Lordship, I have one question from the Supreme Court Advocate, Mr. Gaurav Kumar Jain. If you and suggest as how a judgment should be read and how important are head notes.
That
And
as
Lordship, kindly mute yourself. Yes.
yes, uh, as was very ably explained by the senior advocate, keynote speaker, Siddharth Luthra ji, that you don't have to read merely the head notes. Head notes, of course, is a bird's eye view of the entire judgment. But I would suggest that on the ratio, you should, because as an examinee, you might have to explain the reasons. Supposing if you agree with a view, if you don't agree, then basically you have to, you should focus, first of all, have a clear idea of the facts and circumstances under which the questions arise. What exactly is the issue which is for consideration before the court? Number two would be that what has been the argument advanced in support of the petitioner's case, and countering that, what has been the response of the respondent on that, and then of course the rejoinder arguments also. So on those reasonings, you cannot afford just to read the head notes and just understand the ratio, because many a times, as a counsel, I felt many times that many judges quoted, "Have you gone through that judgment?" And I, for myself, was slightly put off that if only the ratio is given, or even only the cause title of the matter is given, that's not enough. One should know the ratio has been the outcome of the reasons which have been advanced before the court. So I would focus a lot on the reasoning part also of the judgment. So facts would be one. Second would be the arguments advanced. Third would be the judge's appreciation. And finally, the conclusion, which comes as a ratio. So when you prepare a matter, you have to understand and also the ability to summarize as briefly and in a concise way, where the crux is not left out. This, in substance, would be the way, in my view, to prepare the leading cases. And that's for the answers. Right? And if you have to write a judgment, of course, you'll come a long way and you'll learn it gradually. And
Thank you,
I
Lordship.
wish you all
So
of
my
you that you get an opportunity to write the judgments also.
Thanks, Lordship. My next question is from Siddharth sir. Sir, Sheetal from the Gurgaon, she asked that when examiner asks critically analyze a case, what exactly is the examiner is looking for? So may
Examiners
I
will
repeat?
not, I've understood. Examiners will not expect you to just analyze one case. It's like, no, I mean, it depends. If an examiner may say, please analyze a certain judgment, it's possible. Or they may ask you, as I said, compound questions, interrelationship between two sets of judgments, what is, whether one gave rise to the other or there's a conflict or so forth. Now, when an examiner says analyze the judgment, the examiner wants you to bring out the actual facts, gist, in gist, the controversy and dispute. If it's a constitutional issue where questions have been framed, the questions that were framed, how and why those questions came to be framed, whether the questions have been answered, and whether the law in that judgment has been followed or whether it continues to be remain good law, or whether there are gaps in the decision which the judgment ought to have dealt with but has not adequately dealt with, or whether there is the judgment is perhaps per incuriam, it is not considered a binding precedent or a statute. So this is the kind of analysis. It is the analysis. For example, I'll tell you what I would ask as a practitioner of the law, or Justice Mishra would, I assume. At least she used to ask me that. The question is, if the other side is citing a judgment before you, and it's a judgment which is completely against you, how will you come out of it? The only way to come out of it is to have your research, your analysis, and your reading better than the other side, and to build up an argument to try and overcome that decision. So that's the kind of depth that we would require, as an examiner would require you to go if an analysis of the judgment is sought. It's not superficial.
Thank you, sir. So next question is from you that if you have to pick one judgment as your favorite, which one will it be and why is your favorite, sir? Sir is from the Supreme Court Advocate Mr. Vinod Sharma asking that question from you.
Ji, I have a lot of
So what
favorite
is the
decisions. I have a lot of favorite decisions, so I can't really give you a list. But the decisions that I'm partial to, very frankly, are decisions below the 50s and 60s because they tended to be a lot more succinct and crisper. Because those judges were dealing with lesser matters, lesser pressures. They had the ability to analyze and reanalyze a lot more. Today, unfortunately, our Supreme Court judges are under immense pressure. 60 matters on a miscellaneous day, let's say 10 to 15 fund hearings every day, twice a week. We are being rather cruel to them. We are being inhumane to them. Uh, Speaking for myself, I don't want to be unhappy. A lot of the appellate work is pushed out of the Supreme Court, and they are left to deal with issues of moment, issues of constitutional importance, issues where the law is to be settled, and that is important. And that is one of the things that troubles me. So there are scores of decisions, but what I would like about a decision is, and how I appreciate decision is the simplicity of the expression in language and the clarity of thought. That is what makes the judgment attractive to me as a lawyer. Because if the long language is very complicated, if the language is, and if it's very long, then you lose the sense of the decision. So I can't tell you any one decision. There are lots of them, but this is what makes the judgment attractive to me.
thank you, sir. Sir, last question. Gitanjali from Lucknow is asking that kindly explain the creative petition with the leading case Rupa Asokpura. So, can you elaborate a little bit on the creative petition, sir?
Curative jurisdiction was born out of Antale's case, where the courts felt that they had been procedurally unfair to Mr. Antale, and therefore, because they had shifted the trial to the High Court, which did not have original jurisdiction. So Rupa Shubhora comes in 2002 to settle the issue whether an error of law, gross error, can be corrected by the Supreme Court itself after the final decision has taken place. There are two known categories where this can be done. One, where there is a breach of natural justice where you've not been heard. Second, and more important, is when the judge does not disclose their connection with the cause. There are other, these are two illustrative examples, they're not final. It led to the passing of certain safeguard guidelines, senior advocate to give a certificate, AOR to give a certificate, to say that these are errors which need to be reconsidered or issues, and then the matter has to go, and there must have been a dismissal of a review also. So there's after the final decision, there must be a review of the dismissal. Then it goes to the court. Then it's examined in chambers. Then it's seen. If they feel it's a case, they put it up in the before the five judges bench or four judges bench, as the case may be, with the original judges and three other senior most judges to examine whether it needs a reconsideration. There are very few cases which have been reconsidered in curative jurisdiction. It's very rarely exercised. But having said that, it's not that it's not. There are pending curatives in the Supreme Court even today. The Bhopal criminal law case, Bhopal curative was decided, dismissed after a detailed reasoning. They found no reason, but they had heard the matter for, I would say, about 3 weeks or 4 weeks. The other decision, Bhopal civil matters pending, and many other curative matters are pending. For example, the 377 GSX case was pending when Nattej Singh Johar was decided. So these issues happen, and in exceptional cases, the Supreme Court has accepted the existence of a power being a court of record, the ability to correct your own errors. That's the power of a court. I hope that's clear. And now, of course, there are curative rules in the Supreme Court rules. Supreme Court frames rules accepted by the President of India. So they are, in the sense, regulations which are legally acceptable and not just the directions of the court.
Thank you, sir. So, last question and blessings from the Gyansudha Mishra ma'am. Ma'am, you are the role model for whole legal fraternity. So, what is the message for the young advocates? And so, kindly bless them in your words, ma'am.
First of all, I need to compliment you that when you said, I can be a role model, I thought you would say that you are a role model for women.
Yes.
So it's quite a it's a it's a pleasure to know that you have not discriminated compartmentalized it into legal fraternity of women and men. So I think you need to be complimented, and I bless not merely the young aspirants of the AOR examination, but also the entire legal fraternity, especially the upcoming ones, who in whose future, in whose mind and might lies the future of the fraternity. And if I have been saying to the younger generation most of the time, and it's not my punchline. I think some TV anchor had said, and I think I would borrow that expression: "सही हो तो डरो मत, गलत हो तो अड़ो मत." I think this is what I want to convey to the young generation, and that's very relevant for the law courts. Like if you think and you have good reasons, but I think Siddharth has used a very good expression when in his in course of his deliberation, that we do not look into the correctness of the reasoning, but if your reasoning is bizarre, then of course that has to be thought about. So, of course, I express my shower my blessings and wish all the best to the young fraternity of the young legal fraternity, and also try to minimize the litigation, by which of course is a wishful thinking, that one must be a judge of his own cause. Your conscience, I would only repeat myself, which I have said in many a times, that in each person there is a judge. You can yourself judge most of the time what you are pressing is correct or incorrect. If it, a particular situation may be against the rule, but what is right and wrong is the basic dictum for the legal profession. So these, of course, uh, I don't think I'm very articulate in what I'm expressing, at least this part. But in sum and substance, I've said, when you think you are right, you must have the reasons and the courage to say so, and also accept that what the other person, and see the reasoning what other person has to say. Wish you all a great future, a great success, and once again I express I record my appreciation for this wonderful initiative taken by the All India Lawyers Forum. Of course, the AOR Association had been holding the lecture series, but I don't know if this is the first one. Even if it is not the first one, I think you have really contributed in the especially how to take the legal profession through the indirect methods of this webinar. Wish you all a great future.
Thank you, ma'am. The message. So now, may I request to Sunil Fernandez, Advocate on behalf of Supreme Court, kindly give your vote of thanks in respect of our guest.
I would begin by thanking Her Ladyship Justice Gyan Sudha Mishra for taking time out and giving her words of wisdom. Having personally appeared before her court, her enduring memories of appearing before her has been that she has always been very courteous to lawyers, especially the younger members of the bar. And this is something very, if not rare, but not very common to find in the Supreme Court. There is definitely a greater degree of reception to the known faces. But one of the unique traits of Justice Mishra, which we still remember much after she has stopped gracing the Honorable Supreme Court, has been that she has been very courteous, very polite, very kind to the younger members of the bar. There was never a dull moment in her court, as Mr. Luthra rightly said, that she was assertive without being acrimonious. She was very polite, and at the same time, she was very firm. We are very grateful on behalf of the AILF for the words of wisdom, for the blessings that she has given, and we wish her a very healthy and a very happy time ahead, especially in these times, ma'am. Please stay safe, and please continue guiding younger generation of lawyers. You are a role model, not merely for the female gender, but for all young budding lawyers. We refuse to let you be appropriated only by the lady members of the bar. You're a role member for all of us. And as far as Mr. Luthra goes, I mean, I don't. I mean, I was very happy that I got an opportunity to give a vote of thanks to him, because I have briefed him for the last 10, 12 years at least. So I know him on a very personal level. I've known him the way he functions as a senior counsel. And one of the most remarkable traits about him is that in all these 10, 12 years, there hasn't been a single conference, a single case where we have come out of it and he has not advised us on a point of law that everyone has missed. Right from the lawyers in the trial court to the high court to us lawyers who have probably drafted and filed the SLP, everyone would have missed it, and he would have seen one nuance, one point which has been unseen. And more often than not, it was that point, which would have clinched the case. So that, in my view, is the best aspect that Mr. Luthra has as a senior advocate. But there's one trait even better than that I would rate, is that his endearing nature towards the junior counsels, to briefing counsels, to advocates on record. He would always put you on ease, especially before the clients. He would never ever try to put you down before the clients, never ever try to show off that he's the one with all the knowledge and this Johnny knows nothing. He'll always take care to ensure that your reputation, your standing before the clients and even before the court. There were several times when we've goofed up, but he has always owned up our mistakes. He never ever, gave glares to his briefing counsel or to his junior counsels, and that's a true trait of a captain, of a leader. And all of them who are watching this, he is one senior that he would always learn a lot, not merely from the successful prosecution of the matter, but as to various other aspects as to how one must conduct yourself, both in the conference, in the court. And sir, I take this opportunity to publicly thank you for everything that you have done for me and for my chambers. Any number of my juniors have also benefited from your guidance, and we thank you a lot for this time that you have spent in less than an hour. You've encapsulated the entire jurisprudence of Supreme Court from 1947 till now. And if all those who are watching this webinar and they are serious about giving this exam, if only they study the case laws that you have delineated, I'm sure they will also, thank you and be successful advocates of the court. Thanks a lot, sir. Thanks a lot, ma'am.
Thank you so kindly, Mr. Really kind of all of you to have me here. Thank you so much. So grateful.
Thank you.
Thanks.
Thanks a lot.
Thanks for your kind word, especially